all. Yeah. I didn't get any emails, and the law has not been enforced, and I'm explaining the lawsuits, okay? A lot of sheriffs and police officers, mandatory reporters, those elected and appointed to office, those that are generals and admirals don't really understand the lawsuit. So I thought I would take some extra time so that they could enforce the laws because they would understand what the lawsuit means. Now, when I emailed the evidence that the petitioner did not sign the protection order, I was not given actual notice and opportunity to be heard before it was issued, that there are forgeries on those documents, and there are numerous other problems with how that protection order was issued. There's always a question of, well, why didn't they enforce the law in Clallam County? I don't know. I really don't. I've informed a police officer that I want my civil rights. I've informed them that I want my sons. But instead of just doing what the law requires, they decided that they were not going to do what the law requires and they were not going to enforce the laws of the United States. Now, once I had contacted local law enforcement in 2015, and they decided they were just going to laugh it off as if it were a big joke, I, as a father of 5 sons, do not find it funny that my rights are not being enforced, okay? When I email the documentation and I make videos and I am sure about the lawsuit, when I say, oh, it's about 14 million lawsuits, those in office should take this much more seriously than they have. Now, let's say you issued a protection order, okay? And it has what's called a conditional stipulation, a promise stipulation to do something upon condition that a specific event or happening takes place, okay? Now, in July 8th of 2011, when the protection order was not issued according to the requirements of the law, because I was not given notice and opportunity to be heard. See, the court finds, based upon the court record, the law requires the order to say if the respondent received notice of the hearing and by what method. Since the judge needs to verify that service complied with court rules, timely and proper, the judge will probably complete the portion for you. Okay. Now, when you look at in 2011, I was not given notice and opportunity to be heard. That means the law was not done according to what the requirements are. There was no proper and timely notice in the court hearing before they issued the first protection order 6 years ago. Now, when you look at each and every protection order, this was the last protection order issued on 2015 of July 31st. Yes, the respondent did not receive actual notice of the hearing. That means the order was not issued in accordance with the full faith and credit provisions of the Violence Against Women's Act, 18 U.S.C. 2265. Now, it turns out that the Violence Against Women's Act is federal legislation. When you issue a protection order, that could be enforced in every county of the United States. That means every county has jurisdiction, and that means they all have the legal liability for the enforcement of the protection order. That means every county is legally liable to make sure that it's removed. Every county. Now, let's say you put a stipulation here. This order is effective immediately if for 1 year from today's date unless stated otherwise. July 31st, 2025. Now, when you read number 9, okay, there is a stipulation. The respondent will be allowed visitation as follows: no contact until there is a mental health evaluation of respondent and treatment if recommended. Now, the stipulation that the court issued was that if I had a mental health evaluation, they might let me visit my sons. The problem is every protection order for the last 6 years had the same stipulation. When the court, did not issue the protection orders according to the requirements of the law. Now, as the respondent that has gone through exactly what the law requires and why every sheriff and every police officer and every oath of office and every teacher and every medical practitioner is legally liable for the enforcement of this protection order, they themselves are legally liable to have it removed. Now, when you put a stipulation in that I have to have a mental health evaluation for wanting my constitutional rights, I have to have a mental health evaluation for wanting court documents to be issued according to the laws of the United States, I'm not going to have a mental health evaluation. The stipulation in and of itself is a legality. Actually, it is the liability of every sheriff, every oath of office, that they remove this document and they remove all stipulations from me being able to have custody of my 5 sons, considering they never did anything according to the laws that exist right now. Now, I'm not going to move state to state. I'm not going to walk in one sheriff's department after another, after another, after another. I'm not going to try to find the state patrol. I'm not going to try to get a hold of an attorney when I know what the lawsuit says and what it means. To prove negligence on the part of those elected to office, all I have to do is prove that they actually read the document. And considering the hundreds of thousands of emails, there's a pretty darn good likelihood that they're negligent.